Good afternoon, everybody. My name is Paul Tischauer, and I, together with Janet Walker, are delighted to welcome you to the afternoon event on the third day of CanArb Week 2021. Today's event is the Vancouver International Arbitration Center Updates and Award Presentation. Before we get into the event itself, I'd like to take the time to recognize all of our sponsors and supporting organizations. So starting with our sponsors in alphabetical order, Baker McKenzie, Bay Street Chambers, Blake Castles and Graydon, BLG, Borden Ladner Jabet, the Canada branch of the Chartered Institute of Arbitrators, Clyde & Co., Cone Hamilton Stager, Davies, Ward, Phillips and Weinberg, Deloitte, Denton's, Duff & Phelps, a Kroll business, Fasken Martineau, FTI Consulting, HKA, JSS Barristers, KPMG, Learners, NARA Economic Consulting, Omni Bridgeway, Osler, Torreys, and Woods. I also am happy to recognize our supporting organizations, ADRIC, the ADR Institute of Canada, Arbitral Women, Arbitration Place, the Canada branch of the Chartered Institute of Arbitrators, the Canadian Journal of Commercial Arbitration, CPR, the International Institute for Conflict Prevention and Resolution, the ICC Canada Arbitration Committee, ICDR Canada, TCAS, the Toronto Commercial Arbitration Society, VanIAC, the Vancouver International Arbitration Center, WCAS, the Western Canadian Commercial Arbitration Society, and YCAP, the Young Canadian Arbitration Practitioners. In addition, I'd like to just highlight that the Canadian Journal of Commercial Arbitration can be found at this URL, where you can read and download issues for free. Alternatively, you can subscribe for the issues in paper format. And they're very keen to receive submitted articles or case notes for publication in the journal. Now it's my pleasure to welcome you to the VanIAC event and to introduce Barry Penner, who will be our host. Barry Penner is the managing director of VanIAC. Prior to joining VanIAC, Barry was an elected member of the British Columbia Legislature, where he served as Attorney General, the Minister of Government, as Attorney General, the Minister of the Environment, and the Minister of Aboriginal Relations and Reconciliation. Barry, we're delighted to have you with us.
Thank you very much, Paul. Pleasure to be here, and good afternoon, everyone. Speaking to you on behalf of VanIAC, the Vancouver International Arbitration Center. If that name doesn't sound all that familiar to you, there's a reason. We underwent a name change just a year ago in September of 2020. We'd previously been known as the British Columbia International Commercial Arbitration Center, and were established in 1986 with that name. It coincided with the year that Vancouver hosted Expo 86. We had the support of the provincial and federal governments to establish us as part of an effort to create a financial hub in Vancouver. Our board of directors wisely decided last year it was time for a refresh, and we've adjusted our name, so it's Vancouver International Arbitration Center, because internationally Vancouver has more name recognition than, in fact, the province of British Columbia does, particularly following the 2010 Winter Olympics and all the marketing that went into that. So we're a not-for-profit. We administer arbitrations. We have a roster of 130 plus experienced arbitrators, and we've had our busiest year ever in 2020. The pandemic was bad for some things, but it certainly seemed to drive an increase in traffic as the court struggled to deal with commercial cases. We were actually quite seamless in how we adjusted, thanks to the help of our staff, into operating remotely and transitioning from in-person hearings to using video like we're doing right now. We are back to offering some in-person if people so choose. but we're finding that still the majority of arbitrations are taking place just like this on this kind of platform. Without too much further ado, then I'd like to introduce, I'll just say this, the Vancouver International Arbitration Center, we do have a wholly owned subsidiary known as the Canadian International Internet Dispute Resolution Center, which is quite a mouthful. And the acronym is also a bit of a mouthful, CIIDRC. It's got its own website, and that's an online platform for dealing with internet domain name disputes, a form of intellectual property law. So without further ado, then I'll just take you through our presenters that you'll be hearing from in a moment. Sarah McEachran is a partner at BLG and practices in international arbitration and commercial litigation. Sarah is also listed on the roster of Arbitration Place's Next Gen Arbitrators. We also have Laura Kandari joining us today. She is a partner at Blake's, practicing international arbitration and also commercial litigation. Laura is a fellow of the Chartered Institute of Arbitrators and is also listed on the roster of Arbitration Place's Next Gen Arbitrators. And I know she's been busy with the case today, so I appreciate her making the time to be here. Suzanne Anton, QC. Suzanne and I have something in common. We're both former attorneys general from the province of British Columbia. She is the chair of our Strategic Planning and Marketing Committee and also chairs our CIIDRC and Intellectual Property Committee. That's again looking after our subsidiary, which I just mentioned. Prior to joining our board, Suzanne served as the Attorney General and Minister of Justice for British Columbia. We also have joining us today Alexandra Mitra. Oh, I knew I was going to get this wrong. Mitratotis. Alex is an associate at Faskins who practices international arbitration, commercial litigation, and class action defense. She has been named as a future leader in arbitration by Who's Who Legal. Alex is also an adjunct professor at the University of British Columbia. So all together, we have Sarah, Laura, Suzanne, and Alex that will be presenting today. And I'm happy to say they are all members of the board of directors of the Vancouver International Arbitration Center. Does it go back to you, Paul?
So Barry, I think we're going to pass it now over to Suzanne, and Suzanne's going to speak to everyone about some award presentations we're going to do.
Yes, so thank you, Barry. Thank you, Paul and team and the audience who is with us. Yes, so we started in Expo 86 with a great federal provincial initiative to be a center for international arbitrations. We've gone from fairly strong and then there's sort of a little lull, but over the last few years, I would say we really have been going from strength to strength. We're an extremely robust institution. With, as Barry said, we've got over 130 panelists on the commercial arbitration side, and we have another 33 on the CIDRC side. So we have every year an increase in cases, and every year the center looks better and better. But to acknowledge the backbone, really, of the center, we have our staff who are our internal backbone, but the exterior, the group that is there and on our panel is our panelists, of course. And they do such amazing work for the center. They write articles for The Advocate, which is the Columbia Lawyers Magazine. They help us with webinars. They give valuable feedback to our staff who keep an excellent relationship with them. And they grow the community of arbitrations and our arbitrators in our country. We in Vancouver are proud to have the top talent among Canada's top talent in our list of arbitrators. And we're very, very appreciative of having them on our roster. It's good for us, of course, and it's good for them, I hope, and it's certainly good for the arbitration community and for arbitrations generally in our country. So in acknowledgement of that, we wanted to give some awards. So we have, for the first time, have a couple of awards to give out. The first is the annual award for excellence in arbitration, which will be given to this year. In fact, we're giving it to two of our panelists who have gained unquestionably excellent reputations for their exemplary practice as an arbitrator. So top panelists as recognized by their peers. The second award is the award of acknowledgement of significant contribution to VanIAC and CIDRC. Now, this is not an award that will be given out every year. This is someone who has really gone above and beyond in supporting VanIAC and supporting our organization. And we will be giving it out this year for the first time a little later in this program. So we're very pleased to be presenting these awards today. And for the presentation of the first award, I am going to turn this over to Sarah McEachern. Sarah, over to you.
Thanks, Suzanne. This award will be presented to someone who is well known to many of us, both here and of course, internationally. He is highly sought after as an arbitrator for his well-reasoned and eloquently drafted arbitral awards, of which I'm told there are over 100. We know him as a leader, a mentor, a teacher, and for those of us lucky to know him well, as a good friend. This year's recipient of the Excellence in Arbitration Award, well, one of two recipients, is Jerry Geekus, QC. Jerry, you are an extraordinary force in arbitration in Canada and internationally. To name but a few of your accomplishments through your 50-year career, you founded the Western Canadian Arbitration Society, or you're one of the founders. Hi, Jerry. You're chair of the Arbitration Legislation Review Project for the Uniform Law Conference of Canada, chair of the ICC National Arbitration Committee for Canada, VP of the North American Users Council of the LCIA, and Canadian delegate to the UNCITRAL Working Group, to name a few. Yet, despite these many commitments and leading a busy arbitration practice, both at BLG prior to going into your neutral practice now, Jerry, you always have found time to mentor, teach, connect, not to mention correct, the junior counsel coming up under you. I know I'm not alone in saying you've had a great personal impact on my career, as well as many others. Personally have to thank Jerry for pretty much every opportunity I've received in this field. And I know many of your peers and colleagues in the field feel similarly. Jerry, this award is about more than the personal impact you've had on your colleagues and peers. You've been a pivotal person in pushing for the modernization and reform of commercial arbitration law in Canada, from your work on drafting legislation to the time you've dedicated to educating fellow arbitration practitioners, and simply in the way that you run your arbitrations when you're the chair. One younger arbitrator told me a story about how she couldn't find any information she needed online about the Uniform Law Conference. So she reached out to you directly. Half an hour later, Jerry was still enthusiastically discussing the details of it with her over the phone. This is just one example of your dedication, passion, and enthusiasm for improving arbitration. And it's through individuals like you that we all feel inspired to strive for excellence in the practice. You have always believed in promoting and maintaining Canada as an arbitration-friendly jurisdiction, as referred to by Suzanne and Barry, producing some of the best arbitration counsel and arbitrators. Your work with VanIAC, or then the BCICAC, and promoting Vancouver as an arbitral seat are just one example of your work in the area. So it is my absolute honor, pleasure to present the award for excellence in arbitration to Jerry Geekus, QC, and I believe he's got the award there if he would like to show us and share a few words.
I do. Thank you, Sarah. I'll see if I can hold this up. It's heavy. I don't know if you can see it. I have the world in my hands. As you can tell by the fact that I have the award, this moment does not come as a complete surprise to me, but I must say I'm gratified. It was a surprise to me that Sarah would be doing the presentation, and it's very gratifying to me, Sarah, and I thank you very much for your very kind remarks. The award itself is very classy looking, so much so that my wife's going to allow me to display it in my home, and there's no higher standard that I could think of. I've received some other little trinkets along the way. They've been relegated to other places. I've had a great deal of fun over the past 25 years or so, practicing arbitration, and it's been it's been a real privilege to participate in the growth of our Canadian arbitration community. And I think we can all share pride in what we've accomplished over recent years. It's nice to hear you speak, Sarah, of assistance and mentoring and so on that I've done along the way. If I had one piece of advice to give to those who aspire to developing an arbitration practice, it is to do just that. You know, what you give to the arbitration community and the opportunities you create for others, they always do tend to come back to you. It's not a purely altruistic exercise, and it is a heck of a lot of fun to look at the people I'm seeing on the board of directors, for example, of VanIAC now, and to see how much they've accomplished in such a short period of time. I will be very brief. I want to congratulate VanIAC on the recent reinvention, if I can call it, a restatement of its purpose and direction. I have nothing but optimism about the organization with the new initiatives that it's undertaken and the very capable leadership that it enjoys. And I will take the opportunity to encourage my colleagues in the arbitration community across the country and abroad to think about VanIAC as an alternative. It has the added advantage from my perspective, of course, that I'm in Vancouver, and gosh, if you need an arbitrator, what could be handier? But I do congratulate VanIAC very much on what it has accomplished of late, and thank it very, very much sincerely for this recognition. It's much appreciated.
Thank you, Jerry. I will now be providing an overview of CIDRC. So moving on to the next topic. And now Barry has already done the difficult task of explaining the acronym, which is the Canadian International Internet Dispute Resolution Center. I just wanted to give you a highlight, a few points, provide a bit of a report on what CIDRC, which is how I refer to it, is a little easier to roll off the tongue, has been up to over the past 2 years, since it's been almost 2 years now since CIDRC has been running. So as Barry said, this is a division of VanIAC governed by the same board of directors, as well as Barry Penner, QC, being the managing director. And our goal at CIDRC is really just to provide efficient and cost-effective resolution of domain name disputes. So it's quite a specialized niche area, but an area where there are indeed many disputes. We thought some of you here may not be as familiar with what we're doing at CIDRC. So this overview is meant to just provide you with some background so you know what we're up to. Also, you or your clients may be able to make use of our services. You may also be interested in considering signing up as a panelist if you're qualified in the area. So some people may not know that Canada has its own domain name dispute provider, and it's not just for .ca domain names, but for most other domain names as well, can be resolved through CIDRC. CIDRC is the second provider of domain name dispute resolution services in the Western Hemisphere, so it's quite an accomplishment, and we're also the only such service in Canada. CIDRC is one of only 6 such providers in the entire world. So as I said, it's a fairly tight-knit group of providers that administer these disputes. This is an area that VanIAC is very passionate about developing, and it's an area of growth. We've been at the forefront of innovation in the area with a fully online dispute resolution platform. Disputes can be resolved very quickly. Ines was telling me, and it's available on our website, a lot of the disputes are resolved within 35 days, so just over a month. Most are resolved in under 2 months. So what's in a domain name, and what would your clients need to use CIDRC services for? There are over 360 million, I think it is, domain names worldwide. Pretty much every business wants to be on the internet and has a domain name. Domain names have become extremely valuable assets to businesses and for commerce. For example, I was looking up some of the domain names that have been sold, and I was kind of shocked at the amounts that some of them could be sold for. So, you know, one that may not be worth much would be $15, but Las Vegas as a domain name was sold for $90 million. Another one that reportedly sold, but this was a private, so it was just disclosed, I think, in court documents, was the cars.com domain name was sold for over 100 million. So we're talking a lot of money here. So considering the immense value of brands, protecting domain names from use by bad actors is a major priority for most businesses. And I'm sure some of your clients have encountered this. One example that has an unfortunate example that happens to some businesses, and this has become fairly common, is cyber squatting. So this is the practice where a bad actor will register a name, especially of a well-known company or brand, as their own internet domain in the hope of reselling it at an extortionate rate. So rather than paying an exorbitant fee, the rightful brand owner could challenge the registration at CIDRC. So that's an example of the type of cases that we'd be dealing with there. Another type of case might be where a domain name has been challenged because somebody has registered a confusingly similar domain name purposefully to try to redirect traffic that would be going to the valid brand over to their site. So after a complaint is filed that meets the appropriate requirements, the problematic domain can be locked pending pending the resolution of the dispute. So it's quite handy. All of the disputes are resolved through document briefs, so there's no hearing, and they're all submitted through the efficient online platform. The decision is published on the CIDRC website within a month or two of the dispute being filed. There are two types of disputes. So there are the Canadian CDRP disputes as well as UDRP, which are the uniform domain name disputes. Some of the trademarks that have made use of the center services are, I'm sure, household names to many of us: Home Depot, Ford, LinkedIn, TD Bank, HSBC, Calvin Klein, many others, including my personal favorite, Kate Spade. So that's a bit of an overview of the types of disputes that, that are handled at CIDRC. As I said, the online platform is very efficient, easy to use, and is available 24/7 for filing of complaints. The users can efficiently submit their complaint, file the response, select a panelist, and view the decisions resulting therefrom. As Suzanne mentioned, there are 33 panelists right now. And with the number of disputes growing in the area, if you or one of your colleagues have experience in the area, you may want to consider checking out our website and the panelist corner there to see if you would like to and would qualify to become a panelist. So I would just like to conclude in letting you all know about an upcoming webinar that might be of interest to some of the arbitrators or your clients and counsel. Barry Penner will be hosting it along with Michael Ertl and David Lipkus. The title is Challenging Issues in UDRP and CDRP. Those are the two types of domain name dispute cases. Emerging trends and what we all want to know, how to win your next case. So if you're interested, please sign up to join that webinar. Check out the website, advise your clients and colleagues of what we're up to, and consider registering if you've got expertise. Thank you for your attention. I'm now going to pass the mic over to my fellow board member, Laura Kundari, who will update us on VanIAC's domestic rules.
Thanks, Sarah. That was a wonderful way to start with the presentation of that award. And that was also a great introduction to CIDRC and the types of disputes it resolves. Well, it has now been over a year since VanIAC's new domestic rules were enacted. Some of you may have attended last year when I spoke about the rules as we were just unveiling them. I'm going to give a brief overview of some of the key features of those rules and also give you a bit of an update on how uptake has been with respect to those rules. So just as a reminder as to what prompted the new domestic rules, you may recall, or it may be news to you, but in 2020, a new Domestic Arbitration Act was passed in British Columbia. And the prior legislation did not include significant guidance with respect to procedure. Instead, guidance was provided to the parties through VanIAC's domestic arbitration rules, which at the time were the BCICAC's domestic commercial rules of procedure. And those applied under the legislation to all domestic arbitrations seated in British Columbia. The new Arbitration Act includes within it its own more detailed procedural direction. So as a result, it was no longer necessary for VanIAC's domestic arbitration rules to apply by default. However, the parties could, of course, still agree to apply those rules. And under the legislation, VanIAC was given certain functions under the Arbitration Act, including, for example, with respect to the appointment of arbitrators and handling of arbitrators' fees. So with all these changes, it became necessary for VanIAC to revise its arbitration rules to provide some structure for these changes and also to institutionalize some best practices in arbitration and provide parties with some value add if they choose to agree to use these rules in addition to just being under the Domestic Arbitration Act regime. And I think from our perspective, the rules have attracted business to the center. Despite no longer being the default administrator for all domestic arbitrations in BC, VanIAC has retained a similar volume of domestic commercial cases in 2021 so far as compared with prior years. So I'm going to remind you, for those of you who are thinking about rules in your arbitration agreements or your arbitrations that are coming up, about some of the key features of the new rules. The first is the emergency arbitrator provisions. They provide a party with the ability to apply for emergency interim measures prior to the constitution of the arbitral tribunal. And they also provide a party with the ability to apply for an emergency preliminary order to ensure that there's no frustration of the interim measures that may ultimately be ordered as well. VanIAC has a roster of arbitrators ready to hear these matters on short notice and can appoint an emergency arbitrator within 2 days of an application being received. And if you've dealt with VanIAC's office, you know they're incredibly efficient and skilled at doing so. The second key feature are the expedited procedure rules. So one of the major additions when the rules were revised was the inclusion of a new set of expedited procedure rules, which provide an expedited arbitration process with fixed flat fees for arbitrators. These procedures automatically apply if you're under the VanIAC regime to claims under $250,000, or the parties can also agree to opt into using the rules. If the parties agree to arbitrate under VanIAC's domestic rules and the dispute is under $250,000, the rules will apply unless there's a panel of more than one arbitrator specified in the arbitration agreement. The parties can also agree to opt out, or the center determines that it's not suitable for determination under the expedited procedures, perhaps where the value might have been understated, for example. The procedures are very economical. The arbitrator is compensated based on a flat fee of approximately $5,000 where the dispute is under $100,000, and approximately $10,000 where the value is between $100,000 and $250,000. And the reason the fees are possible, and also what makes these procedures so efficient, is that they're done primarily based on written briefs, like the CIDRIC procedure that Sarah mentioned. It is possible to apply to the arbitrator for an oral hearing, but it must be shown to be necessary, and the default is a one-day hearing. And the procedures also proceed on quite an expedited timeline. All written materials submitted within 90 days of appointment, and the award is issued approximately 30 days after that. One of the goals with these new procedures was to increase access to justice for smaller claims, and also to give a more diverse group of arbitrators some experience acting as independent neutrals by being panelists on these expedited arbitrations. And these rules, I think it's fair to say, have been a huge success. Right now, I believe approximately 30% of our domestic commercial arbitrations commenced this year have been brought under the expedited procedures, including some that have specifically opted in to using that process. So parties do seem to recognize the benefit of the efficiency of those procedures, which is great. A couple other quick points about the new rules. There are virtual hearing procedures in there that provide less of a prescriptive requirement and more of a guide for parties as to how they can conduct hearings in what is still mostly a virtual or hybrid arbitration world. And finally, the rules include optional appeal tribunal provisions. So prior to the current iteration of the Arbitration Act, it was not possible to limit appeals to court. The new Arbitration Act, the new BC Domestic Arbitration Act, allows parties to opt out of appeals. And so the rules work in sync with that in allowing the parties more autonomy over how they might have that appeal handled. And the center can provide a private appeal option by appeal to its appeal panel. And the parties can also decide what types of appeals they'd like to have. So under the Domestic Act, it's just an error of law appeal. The parties could decide that they want to allow that there will be appeals on matters of fact or mixed fact and law. So that is a brief summary and update on how the rules are being applied. And I will now turn it over to Alex to provide some information on new international rules that are currently under development.
Hi, everyone. Thanks, Laura. So our current international arbitration rules are from the year 2000, and so we viewed them as needing to be updated and modernized to follow best practices, much the way we did with our domestic rules. And so the board has created a committee to revamp these rules that's composed of Joe MacArthur and Ariel Selassie from Blake's, Craig Chiasson from BLG, Ludmilla Herbst from Ferris, and myself. And we're essentially doing a complete rewrite of the international rules. And so we were hoping to have them rolled out for Canadian Arbitration Week, but as you can probably imagine, it takes quite some time to take that on. And so we're aiming for the end of the calendar year for that. So right now, I'm just going to provide you with a very high level teaser of what you can expect to see. So one key difference to note between VanIAC and some other arbitration centers is we have a different level of case administration than some other international arbitration centers, in the sense that we don't have perhaps as many staff or as many lawyers on staff as some other centers will have. And we don't propose to have our board of directors resolve any issues between the parties, really. And so you'll see that our rules don't provide for as much to be determined by the VanIAC staff or its directors, but rather that the tribunal is really empowered to determine most of the issues. And so where parties are looking to want to have a slightly more efficient administration that may cost a bit less and empower the tribunal to determine the majority of the issues, our rules are going to be appealing there. Our rules are going to provide much of what you would expect in modern international arbitration rules of procedure, such as rules regarding the notice to arbitrate, the answer and the counterclaim, the jurisdiction of the tribunal, the appointment of arbitrators and their independence and impartiality, how to challenge and substitute an arbitrator, how to terminate a mandate, rules governing the conduct of the proceeding, document production, early disposition of an issue, tribunal appointed experts, rules governing the hearing, a default award where one party fails to participate, and then rules governing the closings of the proceedings, the arbitral award, interpretation and correction of the award, and costs and fees. Like with the domestic rules, we will also have interim measures and emergency measures in the international rules. And we've also currently provided for the ability to have a virtual hearing as well. And so all of those things are things you can expect to see. And then on top of that, we're also planning to provide a set of international expedited procedures where the parties agree or where the claim is less than $500,000 Canadian. And so where you have either agreement of the parties or that monetary threshold, our expedited international arbitration rules will apply. And lastly, with respect to the rules, we're also in the process of updating our roster of arbitrators specialized in international arbitration so that parties have a list of selected people that they can speak about that have that experience internationally. And many of them are Canadians who are very familiar with Canadian law as well, but they're practicing international arbitration either in Canada or abroad. So the other thing that we're rolling out, hopefully by the end of the calendar year, is our new online platform, which means that for all cases, domestic, international, expedited or not, you'll be able to submit your case and all further materials throughout the lifespan of the case electronically, and all parties, the tribunal and the center will have access to these materials. The platform is simple and user-friendly, and you can upload everything from procedural orders to pleadings, documents, witness statements, memorials, post-hearing briefs, and the award. The platform will also provide one-stop shop for all of the correspondence with the center and the parties, as well as flagging any outstanding fees that you may owe as one of the parties. The platform will enable the parties in the tribunal to essentially have everything that they need in one organized platform that can be accessed anywhere from the parties or the tribunal at no additional cost to the parties. Lastly, the platform also provides a very handy procedural timeline, which informs the parties and the tribunal at a quick glance in what stage of the proceedings they're currently at. So that's all I intend to say at this point about our international rules and our new online platform, but I'd now like to pivot to presenting our next award. So this feels a bit like the Oscars and getting to present this. This next award is also an Excellence in Arbitration Award. And as Suzanne had mentioned, we had so many votes for 2 nominees this year that we decided that for a first year in awarding these awards, we would award 2 of them. And so I'm very pleased to present our second Excellence in Arbitration Award to arbitrator Tina Cicchetti. And so I'm going to say a few words about Tina before passing the microphone off to her. But so I actually moved to Vancouver from Toronto and joined Fasken because I met Tina during student recruitment that I was doing in Vancouver, and just immediately wanted to work with her and do what she did. So I wanted to do international arbitration. And I was very lucky to get hired and have the opportunity to have Tina assigned as my mentor when I was a student. And so Tina had been with Fasken since she was a student herself. And very early on in her career, she began working with Henry Alvarez, which then led to her being tribunal secretary on many complex, fascinating, and worldwide international arbitration cases with him. I had the incredible opportunity to work on some arbitrations with Tina and some with Henry, and I then had the pleasure of watching Tina make partner at Fasken. Tina eventually went on to become an independent arbitrator with Vancouver Arbitration Chambers, where many of us have watched her career as an independent arbitrator thrive. So I wanted to share some of the comments that voters provided about Tina as arbitrator. So some of these comments include, Tina is a trailblazer for arbitration in Canada. She has the substantive international arbitration experience, but has also been involved in almost every single arbitration organization in Canada and abroad, and has been a tremendous advocate for young female arbitration practitioners. Tina has inspired many women practitioners by her achievements. Tina has 3 children and a busy arbitration practice, yet somehow she gives her time to countless speaking and educational events, one-on-one time to anyone who needs assistance. She has written extensively on a variety of arbitration topics, and she is a true expert in both domestic and international arbitration. Another comment is that she is also of unquestionable ethical character and fair and balanced in her approach to all cases. But I want to touch on one comment that I hear about all the time when people talk about Tina, which is that she's a strong advocate for greater diversity in the arbitration space. And just speaking from the female perspective, I know many young female Canadian arbitration practitioners who practice across the globe. And so many of us refer to Tina as our law fairy godmother. We often will find out any opportunity that we've had when you end up hearing through the grapevine who was in the background puppeting the strings for us, it's always Tina. And so Tina, that doesn't go unnoticed. We all at some point find out it's you in the background advocating for us. Another theme that arises whenever Tina's name is mentioned is how involved and committed she is to the arbitration bar and how recognized and respected she is in and outside of Canada. So Tina is a member of the executive committee of the board of directors of the California International Arbitration Council. She's the past chair of the ICC Canada. She's a board member of WCAS, a former president and current advisory board member of YCAP, a member of the ICDR Canada Advisory Committee, and a former ICC YAF member. Tina was also appointed by the Canadian government as a member of the NAFTA 2022 committee and invited by the Attorney General of BC to join an arbitration advisory group on legislative reform and promotion of Vancouver as a seat for international arbitration. She's also a member of the ITA Board of Reporters for Canada, and she was appointed by the Canadian government to the roster of candidates to serve on the Canada, US, Mexico trade agreement panels. Tina has been ranked by clients and peers regularly in Chambers, Gars Hoo-Hoo Legal, The Best Lawyers, Benchmark, and Lexpert as a leader in international arbitration. Tina is a practical arbitrator with excellent judgment. She is gracious with her time and expertise, and we are very lucky to have her in this field in Canada, in Western Canada, and internationally. So congratulations on the award, Tina. I understand you're in New York and you don't have the physical award with you, but I'll now pass the microphone over to you to say a few words.
Thank you, Alex. I'm not sure I can speak. I'm a little verklempt, actually. Lovely words. I am incredibly honored, not just to receive this award, but to share it with Jerry. Because as Sarah mentioned, he has had a hand in so many of our careers. And I had the great fortune of having him be a sponsor for me when I was at sort of that pivotal point in my arbitration career and needed a boost from someone senior. So that is something that I've always sought to emulate. I very much appreciated that help, and hopefully I've paid some of that forward to others. You've all absolutely earned every opportunity you've gotten and done a great job with it. So don't feel you have to thank me. I just, along with what Jerry said, wanted to say a few things about the BCICAC and how important I think it is. I say BCICAC because that's what it was called when I was a baby lawyer, and it's been a fixture, in arbitration practice the entire time that I have been practicing. And it's been a real pleasure to see it rebranded as VanIAC and starting this new chapter. But I think we shouldn't underestimate the value of its contributions in, being established in 1986 with Expo, which I remember attending as a child, and having an arbitral institution that was there, implemented at the same time that the BC was taking on board the model law for international commercial arbitration. And I think if you look around the world at seats that have become go-to seats for international arbitration, one feature that almost all of them have in common is an arbitration institution and a culture of institutional arbitration. And ad hoc arbitration, as we know, can work very well in many contexts, in particular domestic or situations where you have parties from similar backgrounds. But I think it is fair to say that when you have parties from very different international backgrounds who may come from different legal systems and have different ideas, that it can be extremely valuable to have an institution there to just help level the playing field and make the process much more efficient for everyone. So I am very proud to have grown up in a jurisdiction that has that culture of institutional arbitration. I look forward to VanIAC's continued success in attracting arbitration to Vancouver, because like Jerry, I benefit from that. I love being at home. It's a beautiful place. You never appreciate it more than if you move away for a little while and then come back. But I think it has had and will continue to have a very important role. And I am very proud to be from this jurisdiction, and thank all of you for this recognition.
Thank you, Tina, on a very well-deserved award. I'm going to pass it over to Suzanne now, who's going to present our next award.
Yes, thank you, Alex, and congratulations, Tina. Congratulations, Jerry. Thank you for your kind words about VanIAC. It is nice to see it rebranded. I've got to say, I appreciate the appreciation we're getting for that, because going through a branding is quite a lot of work and a lot of thought and consideration, and it has turned out, I think it has turned out extremely well. Not only are we rebranded in our name, but we are rebranded as an organization. And as a number of people referred to, it was started up in 1986. But I was, as Barry said, both he and I were attorneys general, and I was there about 5 or 6 years ago when I thought one of the ways to keep things out of courts and help your court system is by, of course, by arbitrations rather than courts. So we set up a committee of arbitrators to help us out. And I think Jerry, Tina, and the next recipient were all on that committee and really have continued to provide invaluable advice to our organization. The third award, or the third recipient, is the second award, is the award of acknowledgement of a significant contribution to VanIAC and to CIDRIC. And as I mentioned earlier, we're not going to give this out every year necessarily, but this year there was a person who will be awarded to, Ken Glazner, Queen's Counsel, and he was pretty much, Ken, a no-brainer to be our first recipient of this award. And here's some of the reasons why. The center did go through a number of very significant changes a few years ago. It was challenging for staff, it was challenging for the board. And there were a lot of difficult decisions that had to be made. Sometimes things were a little rocky. Staff needed someone to lean on, someone who they could rely on for advice and for help. We had a board member at that time, Ken, who had been a member for 7 years and was a member overall for 7 years, but has continued to act almost as though he's a board member in terms of his continued support to our organization, his reliable help and advice to our organization. And it led to us getting new offices downtown, a new vigor to the organization, this highly qualified, as I referred to, highly qualified panel of arbitrators, and to where we are today, a growing organization, a well-regarded organization, and with the top talent in our country on our panel. So Ken is not only been a great help to us, but of course he is a leader in the field of arbitrations as a counsel, as an arbitrator, as a prolific writer, as a friend of our organization. Ken has a number of panels that he sits on. He's on the ADR chambers. He's a member of the Law Society Task Force on Alternative Dispute Resolution. He's a lecturer. He helps draft arbitration and mediation clauses and dispute resolution. He was a JP for an adjudicator for the province of British Columbia. He's the honorary legal counsel to Congregation Shara Zedek. He was a member of my arbitration group that we set up a few years ago. I happen to know because we occasionally talk about this. He's a golfer. He's a community member, a devoted community member, a leader in a number of different communities in Vancouver, a proud grandfather, and now the first recipient of our award for special contribution to VanIAC. Over to you, my friend Ken.
Thank you, Suzanne. First, I'd like to thank VanIAC's team for this award. I especially appreciate that Suzanne Anton is the presenter. Let me reply in kind. Suzanne, you may recall as Attorney General for BC, you called some years ago asking that I be part of the Arbitration Advisory Committee. You had cobbled together a dozen or so arbitrators to assist in further developing an acceptance of arbitration by the business community as an alternative to litigation. You then had the full cooperation of the then directors of BCICAC, now referred to as VanIAC. With Jonathan Eads' assistance as the quarterback at the ministry, you initiated a review of the existing legislation. Your interest didn't stop there. You joined BCICAC as a director, the result of which, with the assistance of your colleague, Barry Penner QC, former Attorney General, Joe MacArthur and others, VanIAC implemented a new set of domestic rules which came into force on September the 1st, 2020. Those new rules dovetailed into the new act. Your initiative started with the result of two pieces of progressive arbitral legislation. In addition, the new board was fortunate to have an A team running the show, Erna Mead and Ina Ergasheva. The two-part seminar last May titled Nose to Tail, a phrase coined by my co-coordinator, Joe MacArthur, which VanIAC put on along with the co-sponsorship to the Chartered Institute of Arbitrators, I thought went well. 535 registrants from 18 countries with a faculty of some 13 senior arbitrators. The present challenge is to how do you impart to lawyers the need to redirect their reasoning and their competitive spirit in advising their clients in resolving disputes. It requires a paradigm shift. VanIAC has been there to assist in this shift. VanIAC has, as the expression goes, stepped up to the plate for problem-solving lawyers, assisting them to make the necessary transition. Thank you for allowing me to be part of that team.
Thank you, Ken. Well, so much of where we are today is because of your help over the years. I know that, and I'm very glad to hear you acknowledge Ina and Erna, of course, because they have been so appreciative of your advice and help over the last few years, and they continue to be the backbone of our organization. So thank you everyone for being here. That is our program. As you can tell, in Vancouver, we are extremely proud of our arbitral institution, VanIAC. We're proud of our panelists and our staff. We have a wonderful board, and we have very interesting new directions. The CIDRIC taking on the international domain name disputes is, as was mentioned, we are the only one in Canada and the first, only the second in North America. We also do the .ca dispute. So any of you who have a domain name .ca, bring it to us because we will handle it for you. We're, as has been mentioned, we are really in the forefront of the online platforms, both with the CIDRIC and now with the arbitration online platform, which is just being rolled out now. I think anyone who uses it will find it should be just an excellent one. Excellent system. I was playing with it today, as a matter of fact. Easy to use, you don't even need to be intuitive. It's very, very straightforward to use. And as was referred to, everybody will have exactly the same documents. Nothing can go missing because it's all got to be right there in the same place. So we are very proud of our organization, VanIAC. Thank you to everyone who has been with us today watching. Thank you to our presenters, and congratulations again to Tina, to Jerry, and to Ken. And with that, I don't know if there's going to be any questions. If there are, Barry, I think I'll pass it back to you. And I will say thank you to everyone for participating today.
Thank you, Suzanne, and thanks to all of our presenters and our award winners. I think you'll agree with me that it's a very deserving group indeed. Now, if anybody is so inclined, I think we do have time for some questions. Alex is my boss here, or maybe it's Sarah. I think it's Alex. How much time do we have?
We actually do have 5 minutes if anyone had any questions or comments from the audience.
Perhaps I might say something then, Alex, if I could just jump in and congratulate all 5 of you from VanIAC for putting on a wonderful, informative, and encouraging presentation. And particularly congratulations to our 3 award winners, your 3 award winners, Jerry, Tina, and Ken, all of whom I know well. So it's a pleasure to be able to have something like this be a part of CanArb Week and add to the luster of our week. And we're delighted that you're here with us. So congratulations to all of you.
Thank you.
Okay, well, unless there's any other comments, maybe we'll just let people have a few minutes off. But thanks so much for including us in CanArb Week, Paul.
Great, our pleasure. Absolutely.